All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
And welcome to the Court of Appeals. I'm Judge Valerie Zachary. To my right is Judge Julie Flood, and to my left is Judge Allison Riggs. Assisting us today is our clerk of court, Jean Soar, and Officer Richard Remillard. And I have forgotten your name already. Delana McKesson. Thank you, Delana. On the calendar this afternoon is Bartels versus Franklin Operations, LLC et al. On appeal from Wake County Superior Court. Have you already discussed rebuttal time?
Yes, Your Honor, though we take 5 minutes for rebuttal.
Great. Let's begin.
Thank you. May it please the court, Your Honor, Your Honors, my name is Scott Basil. I'm with the law firm of Parker, Poe, Adams, and Bernstein. I'm appearing today on behalf of the defendant appellants, Franklin Operations and Sabre Healthcare Group. Your Honors, this appeal presents the question of whether the plaintiff may litigate claims based on the supervision and care that his mother received at the Franklin Manor Assisted Living Facility when the plaintiff already litigated those matters in federal court against these defendants and lost. And Your Honors, we submit the answer to that question is no. And that is because plaintiff is barred from doing so as a matter of law under the doctrine of collateral estoppel and separately the doctrine of res judicata. In this case, plaintiff alleges that Franklin Manor failed to adequately provide for his mother's safety, supervision, and care needs. And the plaintiff alleges in this case that the supervision and care his mother received did not conform to the applicable standard of care because of insufficient staffing. But plaintiff litigated these matters against the defendants in a previous federal court action, and the defendant decided all of those matters against the plaintiff. The federal court determined, after 5 years of litigation, that the undisputed evidence established that 1, defendants had satisfied the applicable standard of care in providing services to the plaintiff's mother. Number 2, the plaintiff's mother had her, quote, needs met by adequate or above average care at Franklin Manor. 3, his mother received services needed for her safety and well-being needs. 4, there was no evidence to show that Franklin Manor's staffing negatively impacted its mother's care. Indeed, the federal court, when analyzing the allegations of the federal complaint, found that the plaintiff had conceded the, quote, heart of that case, the issue at the heart of that case, which was that the plaintiff's mother had her needs met at the facility.
Well, excuse me, weren't they actually suing under contract in federal court, and then the case now is for negligence?
That's right, Your Honor.
So are those really the same injury?
Well, Your Honor, the injury, the two doctrines of the collateral estoppel is the preclusion of an issue. And here, even if the damages are different, even if the theories of recovery are different, theories for damage, collateral estoppel still precludes the relitigation of that particular issue.
Well, was it actually relitigated though? If you're really looking in negligence at the standard of care, was that actually litigated in a contract case?
Yes, Your Honor, and we have to look back at what the federal court did in that case. So in that lawsuit, if we go into look at the subject matter, and the plaintiff argues in his brief, you got to look at the allegations as well as the federal court's final judgment. And that's what we did in the brief. If you look at the allegations, what plaintiff was pursuing there, it was under contract. And the theory was to try to proceed under a class action. Now that theory failed and it turned into be an individual claim for the plaintiff. But the contracted issue was that Franklin Manor would provide services sufficient to meet Ms. Bartels' safety, good grooming, and well-being needs. And as alleged in the federal action, that included assistance with walking, toileting, housekeeping, grooming, eating, delivering medications, and overall supervision to ensure that Ms. Bartels remained safe. Those were the material terms of that particular contract. And plaintiffs alleged in the federal case that the defendants had failed to meet those needs, including the provision of providing adequate assistance in walking and supervision. In this complaint, Your Honor, they're the same allegations. As in the federal action.
Counsel, before you move on to the state court case, I want to ask a couple of questions about the federal case. Am I right that what was alleged in the complaint in the federal case was a breach of contract based on inadequate, not meeting the services provided, and what the plaintiffs, according to Judge Boyle, did in their response in opposition to the motion to dismiss was have a different theory of the case, a breach of contract by violation of North Carolina staffing law. Is that right?
That was the argument they made in response to summary judgment.
So as a matter of law, Judge Boyle determined that the breach of contract with respect to the services provided was waived, but it's not like plaintiffs just conceded that the service of care was, the care and the service provided was adequate. Is that right?
Yes, Your Honor. So when the matter proceeded after the class certification was denied, it became an individual lawsuit with regards to Ms. Bartels' care and supervision. And the allegations, which included assistance with walking and care, so then therefore the defendants put in expert testimony as to whether or not the standards of care for supervision and care were met. Plaintiff came before the federal court in response to summary judgment because the federal court had put the standard of care directly at issue and said, federal court, defendants are wrong. That's not what we're alleging in the federal action complaint. We're not alleging anything about the standard of care. And Judge Boyle in the Eastern District said, no, I'm looking at your complaint, and the standard of care, the care that plaintiffs in fact received and whether or not those care needs were met, that was, quote, the heart of the issue in the federal case.
But he, as a matter of law, said they had waived the arguments as he understood them and as defendants understood them, and that they were, I think, deliberately refusing to address those, but it was a matter of waiver for bringing up a new argument in an opposition to a summary judgment. Isn't that right?
No, Your Honor. It was a matter of failure to provide evidence to rebut our evidence. We had the expert witnesses on the standard of care. We had the expert witnesses saying that Ms. Bartels, what her needs were, how they were, what type of care she received, and whether or not those needs were met. The plaintiffs did not present sufficient evidence to rebut that. Therefore, the federal court held that as a matter of law, the undisputed evidence showed that her care was met, what her care needs were, and that her care needs were met.
Excuse me. So you're talking about the standard of care. Are you saying the standard of care that was necessary to meet the terms of the contract? Or, and if that's what you're saying, isn't that different than the standard of care under a negligence theory?
Your Honor, too, and I think we can go where the standards of care, if you're suing for negligence and if you're suing for if you're suing for negligence and you're suing under a breach of contract, they could be different. But what Judge Boyle in the federal court was looking at is that here, it was whether or not the contract says you will provide adequate assistance with walking to ensure Ms. Bartels' safety. You will provide adequate services to meet her health, well-being, and safety needs. So that contract then is about the care. You stated differently, you can't provide adequate, if the contract requires you to provide adequate care, you are really invoking the standard of care, the negligent standard of care in that.
So the way you see it, the allegations of inadequate staffing, they're the same as saying inadequate supervision and care.
Well, no, Your Honor, I mean, the federal court, in there was about supervision and care. In the federal court, if you look in the record at 105, which is paragraph 49 of the plaintiff's complaint in the federal court, that contract provided for, and what the issue was, assistance with walking and also overall supervision to ensure that Ms. Bartels remained safe. That was a key allegation in the federal court. Here, it's the same. The allegations, if we look into her action here.
But what do you do with the difference? So as I understand, the experts in the federal case said this wasn't about any one particular incident or fall. This is about the facilities, the care generally. In a negligence case where you are talking about a specific incident because you have to prove causation, how do you deal with the fact that the experts in the federal case didn't address those particular falls?
Well, Your Honor, what the expert in the federal case was addressing is that she was there for a 10-day period, and they were challenging the care she received during that 10-day period. So the expert was saying, there's not one particular instance that I'm looking at here. I'm looking at all of the care during that 10-day period. The falls, which are the subject matter and put into this complaint, those falls were directly addressed by that expert. And they were directly addressed because the complaint in the federal action, in paragraph 49, put that issue directly in there, which said that she's going to receive assistance, adequate assistance with walking, and overall supervision to ensure her safety. That's why the expert then looked at the falls at issue and found, in the expert's opinion, that those falls were not caused by the care or lack of care at Franklin Manor. And Your Honors, that's the particular issue that's here at this case. Now, Your Honors, if we look at also, even if the doctrine, even if that particular issue, to look at whether it's a negligence claim and a contract claim, if the duties are the same or not, even if that's troubling the court, and again, I don't think it should, because the federal court, I think, made it very clear that we're looking on the two same issues here. But even if they were different, the action is still barred by the prohibition against claim splitting.
Well, I just have one more question. Couldn't you have adequate staff in your facility and still not have adequate supervision and care for a particular resident?
I believe that is absolutely the case, Your Honor, but the federal court found that her care needs were met. The federal court found that the applicable standard of care for her care was met. It wasn't just about staffing. The court did find there was no evidence that staffing negatively impacted her care. But if in the record at page 270 to 71, based on the undisputed evidence, there is a federal court judgment that holds that defendants had satisfied the applicable standard of care, that her needs were met by adequate or above average care, that she had her safety and well-being needs met. If the plaintiff believed that Judge Boyle in the federal court misread the complaint, committed legal error in making those conclusions, the plaintiff had but one option, and that was to appeal to the Fourth Circuit Court of Appeals. And the plaintiff did not do so. Those findings, those determinations are binding. There is no jury in a state court. I mean, indeed, a verdict for the plaintiff in this case would require a finding directly contrary to the federal court's final judgment, which was not appealed, that the defendants had failed to satisfy the applicable standard of care, or that the defendants had not met her needs, that she was not properly supervised. Those are all determinations that are final already and binding on plaintiff, and there was no appeal to the Fourth Circuit. But, Your Honors, res judicata, even when going back to the issue of the contract, what the standard of care versus contract and tort, even if those were different, the plaintiff is barred by the prohibition against claim splitting. Res judicata bars parties from relitigating both the same issues, the issues that were actually determined or litigated in a prior proceeding, and number two, which is critical here, all relevant and material matters within the scope of the proceeding which the parties in the exercise of reasonable diligence could or should have brought forward for determination. That second aspect is what our Supreme Court calls the prohibition against claim splitting. Under the prohibition against claim splitting, all damages incurred as the result of a wrong must be recovered in one lawsuit. A plaintiff cannot split the attempts to recover damages into two lawsuits. For example, pursuing contract damages in one action and then turn around and pursuing tort damages in another action. That violates the prohibition against claim splitting. Because as this court, the Court of Appeals held in Skinner v. Quintiles in 2004, res judicata cannot be avoided by simply shifting legal theories or asserting a different ground for relief, contract damages versus tort damages. And as this court also held in Skinner, res judicata applies if the two lawsuits, quote, stem from the same relevant conduct by the defendant. And your honors, here, the instant case and the federal action most clearly stem from the same relevant conduct by the defendants.
Did the court actually look at because she fell twice, right? Am I correct?
I believe the complaint has 2 or 3 falls.
2 or 3 falls? Okay. Did the court actually look at each of those incidents, each of the falls, to determine whether she was receiving adequate care each time she fell?
Your Honor, I will be honest, I can't read into Judge Boyle's mind as to what he considered on those particular falls when he determined that, based on the evidence, that the standard of care, that all applicable standards of care had been met. Mm-hmm. Those, though, however, were materials that we submitted, obviously, in support of our motion for summary judgment. We had an expert opinion from a licensed physician of 40 years in geriatric care that looked at the records of what her care needs were, the fall records, and said that it was not based or caused by any lack or any inappropriate care by Franklin Manor. That's what the judge had in front of it. There was no evidence before the court, because the plaintiffs had not submitted it, to rebut that. And that's when the federal court said, plaintiffs, quote, missed the boat. You had an opportunity. I denied class certification because this was going to be an individualized issue on care. You can't proceed as a class action. And you had an opportunity to come and present rebutting evidence, and you did not.
So I think I understand you to be saying that there can be a difference in the care contracted for as opposed to the standard of care in a negligence case. If you want to contract for 1,000 thread count sheets, you can do that, but it's not the standard of care. What about negligence sort of adjacent to the having of a facility? So for example, the care provided, you get the medicine you need, you get the doctor's care, but there's a visitor to the site, and maybe he or she does something that the facility didn't expect but could have anticipated, or there's a cleaning cart just in the way for a few minutes, sort of anticipated but not part of the care. Is that something that you can that be distinguished too in terms of a negligence suit versus what you contract for? When you let me put it another way. When you contract for residents at a facility like this, are you contracting for every possible situation, or are there situations that might fall into typical tort or negligence areas that are outside the scope of the contract?
Sure. So if we're talking in terms of the prohibition against claim splitting, what the courts have held on that is that where we're talking about the same relevant conduct, you have to bring all your claims together. I'm not arguing you can't have a negligence claim and in the alternative say it's the contract claim, or present both and seek different damages potentially under both. But if it relates to the same alleged conduct, the same alleged wrong in there, then you have to bring them all together. So if it is a contract claim and a tort claim related to, in this case, let's say alleged inadequate supervision, maybe it's because of inadequate staffing, yes, you would have to bring your contract claim and your tort claim together, or you would be barred from bringing one later. That's the prohibition against claim splitting. Now, if they're based on different conduct, and that was the Bachweg case, if you're referring in the Supreme Court, where you
That's
had...
what I was just getting ready to ask about, because
Where-
aren't there multiple wrongs here, like in Bachweg?
Well, no, Your Honor. I mean, there can be alleged multiple wrongs, but as we pointed out, they're all alleged in the federal action. What happened in Bachweg was you had two very distinct things, where a failure to monitor nutrition, which caused brain damage, and then a failure to diagnose pelvic infection, which led to the loss of reproductive organs. So those are two different things here, whereas in here, we're talking about the care and supervision, and specifically in here, assistance with walking and the falls, which is one of the specific allegations in that complaint. Bachweg is also a little different, because there, the interesting part of Bachweg, Your Honor, if you read the history, is that those two claims were originally brought together. The plaintiffs, with the stipulation of defendants, agreed to dismiss one of them so the trial would only proceed as to the other claim. What the Bachweg court was also saying is, well, therefore, that dismissal took all of those allegations out of the lawsuit. So they couldn't have possibly been part of the case, because that dismissal, which was stipulated to by the defendants, would have removed those allegations out of the lawsuit, which is a very different situation than we have here. And Your Honors, on the two, and we did look in all sorts, it is not often, admittedly, where we're dealt with a situation where someone brings a contract action based on care and then subsequently brings a tort action based on the same alleged wrong. It does not happen. I did not find a case directly on point in North Carolina on that. I think the law in other contexts is very clear. But we did find, and they're cited in our brief, two out-of-state cases which we were able to find that did address this. And one of those cases, Your Honor, addressed the issues that we were talking about here of the difference potentially between a contract claim and a negligence claim. That's the Walton case out of Mississippi. There, the first action was a tort claim for negligence concerning the removal of an ovarian cyst. The defendants were granted summary judgment. The second action was a contract claim for breaching a contract to properly remove the ovarian cyst. And the court argued that res judicata or collateral estoppel could not apply because a contract duty and a tort duty was different. And the court rejected that and said the duties may be different, but that was of no consequence. The plaintiff was trying to bring a new theory of damages recovery based on the same alleged conduct. Quote, clearly the breach of contract was a ground upon which the plaintiff may have sought recovery in the previous lawsuit, unquote. And then they said in there in the holding, where one has a choice of more than one recovery for a given wrong, there could be a contract claim and a tort claim. She may not assert them serially in successive actions, but must advance all at once on the pain of the bar of res judicata. Your Honor, there's also another case which holds similarly out of Connecticut we found in 2007. But the alleged wrong in this case, which is that defendants failed to provide Ms. Bartels with adequate supervision and care during her 2-week stay at Franklin Manor, is the same as the alleged wrong in the federal action. The only difference is plaintiff's theory of recovery. In the federal action, plaintiff sought contract damages for the defendant's alleged failure to provide adequate care. In this action, she seeks tort damages for the same thing. That is textbook claim splitting. Your Honor, I wanted to also briefly address, because the plaintiff's argument about somehow we consented to claim splitting. Your Honors, we objected right in our answer at the very beginning, in the first pleading in the case, and pointed out that there is another action proceeding on the same claims or on the same or substantially similar allegations. So we objected. That's in the record at page 17. We could not, of course, have moved to dismiss then because both doctrines require a final judgment on the merits. We then notified the court by a notice of filing. I believe it was 2 or 3 days after that final judgment became final. The appeal was not taken, and we moved for summary judgment on that exact day. So we did exactly what the law in Bachwick requires, which is we timely objected, and we did that right in our initial answer.
You have 1 minute before you get into
Yes, Your Honor, and I was just, in our brief, we also lay out for collateral estoppel the 4 elements, and we believe on there, as we've said in our, out in there, that all 4 of those elements are easily met here. And I also, when we're talking about the overlap of issues, I think it's important to note that plaintiff filed a motion in this case, the instant case, in March of 2019, where the plaintiff sought to use the discovery from the federal action in this case, which of course we objected to, because had we not objected, we would have been accused of consenting to claim splitting, which we would not do. But in that, the plaintiff here stated that there were overlapping factual issues and that they shouldn't have to do the same depositions on the same topics that were happened in the federal case, and that engaging in the same written discovery that had already been served and produced. These are the same issues. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. My name is Steve Guggenheim. I represent the plaintiffs and appellees in this matter. It seems like the defendants, appellants, have spent basically all of their argument and essentially all of their briefing on the issue of the affirmative defense of res judicata. Well, we have to step back a moment and look at why do we have res judicata? What is the purpose of res judicata? And in fact, an opinion from the Court of Appeals came out today that discussed the res judicata defense. And the court said today, as has been said for many years, that the dual purposes of res judicata and collateral estoppel are to protect litigants from the burden of relitigating previously decided matters and promoting judicial economy by preventing needless litigation. For almost 4 years, the defendants vigorously defended not only the federal action, but the state court action, taking numerous depositions, filing expert reports and expert designations for 4 experts.
Well, what do you think that they should have done?
Well, first of all, we don't believe that res judicata applies, and we'll get there. But the Supreme Court said in Bachwick, wait a second, we understand that you can file an objection. We also understand that the res judicata defense and the collateral estoppel defense can't be resolved until there's a determination on the merits in the federal court case. But the Supreme Court acknowledged, well, wait a second. That doesn't mean that you can't move to dismiss the subsequent action. Because if the defendants truly believe that the claims in this case were the same as those in the federal case, they would have moved to dismiss, arguing, Your Honor, these same issues and the same wrongs were pled in the federal court action, so this case should be dismissed. But the defendants didn't do that. How does that promote judicial economy? How does that prevent needless litigation when for 4 years the parties took 12 depositions, designated 6 experts, entered scheduling orders, protective orders, and the defendants even moved to continue the trial that was set last year or 2 years ago in 2021, not because of this other litigation in federal court, not because the same issues were being litigated, but because the defendants weren't ready for trial.
Let me go back, following up on Judge Zachary's question. I get that your position as defendants should have moved to dismiss even before there was a final judgment, but on page 15 in your brief, you also say they should have consolidated this action with the federal action. How would defendants have gone about doing that?
Well, they could have filed a motion to consolidate the cases because if they truly believed that the same claims were the subject of the federal action, then the state action should have either been dismissed or consolidated with the federal action. I think the more appropriate position the defendant should have taken is these are 2 cases about the exact same thing, the exact same issues, the exact same wrongs, and again, we don't agree with that position in any way, and therefore the state court action should be dismissed. But the defendants knew that the state court action had nothing to do with the claims in the federal court action because they litigated it. They vigorously defended it. Now, why would they have done that for 4 years if they thought that the federal court action addressed the same issues, the same wrongs, the same claims? That defeats the whole purpose and underlying principles of res judicata is to engage in the conduct that the defendants engaged in. And so the Bachweg court acknowledged that. And in Bachweg, it was only 5 months. And the Supreme Court said, well, wait a second. You litigated this case for 5 months and didn't take any action. Whereas here, we're talking about 4 years and multiple depositions and orders and designations of experts.
And so it's your contention that just objecting in your answer is insufficient, and that the fact that they defended both claims simultaneously shows that, or provides evidence that they understood that both claims would be treated separately.
Correct, and implicitly consented to claim splitting, which they now so vehemently object to. And going beyond that, I think we have to also look, well, first of all, the defendants made a big deal and continue to emphasize the federal court's order. The federal court's order is irrelevant to the analysis as to the applicability of res judicata. That's been stated in every case. That is not the law. The question, and again, let's assume the court says, no, they didn't waive it. The court still has to answer the question of, does res judicata apply? And the defendant's position is that it does apply because we're talking about the same wrongs. That the plaintiff pled the same wrongs in the federal court action as she pled in the state court action. The federal court action was a breach of contract claim that related to the provision of services. Did the defendants provide the services that they agreed to provide in the residency agreement? That was the only issue. That was the only wrong. And the wrong, as pled in the federal complaint, which is the only important and relevant document, is the complaint. There was nothing in the complaint that said the defendants provided all the services, but they didn't comply with the standards of practice when they were providing those services. The federal action dealt with the quantity of services, not the quality of the services that were actually provided. And as Judge Riggs asked the question of the appellants today, well, can you still have a case where the defendants provided all of the services, but those services were not provided in accordance with the standard of practice? And Mr. Basil answered that question, yes. And that's exactly what we have here, is there was never a wrong asserted in the federal court complaint regarding the quality of the services that were provided. In fact, the federal complaint was the opposite. It had nothing to do with the quality of services. It only had to do with the fact that the plaintiffs alleged that the defendants didn't provide the services that they said they were going to provide in the residency agreement. Now, the law of North Carolina doesn't allow a medical malpractice claim for personal injuries to proceed as a breach of contract. The contract, there can be no contract to establish the standard of care. The standard of care is based on expert opinion that's required before you ever file a medical malpractice action. And in fact, under Rule 9J, before you ever file a medical malpractice in North Carolina, you have to have an expert who certifies that they are willing to testify that the defendants failed to act in accordance with the standards of care. That didn't exist in the federal complaint. There was no allegation that the defendants failed to comply with the standard of care. And if the defendants truly thought that it was a medical malpractice claim for personal injury, the case would have been dismissed like that because there was no Rule 9J certification. But that never happened.
Well, how do you respond to defendant's contention that the adequacy of plaintiff's care was actually litigated in the federal case?
Well, that goes to the issue. Well, first of all, whether it was litigated in the federal court, it wasn't litigated. It was manufactured by the defendant, and the only thing they submitted was an expert report, which wasn't even verified. It was just attached to a motion for summary judgment. There was nothing litigated in the federal court. There is not a shred of evidence in the record in this case that anything related to the November falls, related to whether or not the defendants complied with the standards of practice, how those falls occurred, who was involved, who witnessed them, nothing in the record about that issue that the defendants have provided. Not one thing.
So Judge Boyle made, well, first he said plaintiffs waived this new, they conceded their argument in the complaint and they can't bring this new one. But then he turned to, allegedly, the merits, and he made a big deal about plaintiff Fall. I don't exactly know how you pronounce his name, but
Full.
Yes.
Yes.
Made some to-do about him conceding that the standard of care had been met. But it wasn't clear to me, one, I don't think that document's in the record, and do you know whether plaintiff Bartels made a similar concession?
Well, again, I think, well, first of all, a plaintiff can't testify about standards of practice or standards of care. They're not competent. They're just ordinary lay people. And the issue goes to, though, not what the plaintiff said or anyone said. What goes to is what was pled. What was in the federal complaint? And the law says, well, wait a second. And before you analyze, the judgment doesn't matter. What Judge Boyle said in his order is irrelevant. what the court has to look at is what was necessary for the determination of the underlying issues that were pled in the complaint. All right? I can go through the complaint and point out to you that the only issue in the federal complaint related to staffing and did the defendants provide sufficient numbers of staff on duty that would have allowed them to provide the services they promised to provide. Nothing else. That was the only issue, is did the defendants staff the way they said they were going to? And that's what the plaintiff paid for. And that's why she filed a breach of contract claim, not a medical malpractice claim, because there were no injuries. She didn't allege any injuries. She didn't plead any injuries. She didn't plead any violation of the standard of care. She didn't even mention the falls. Not one word. So what the defendants say is, oh, whoa, wait a second. You pled a breach of contract case, and therefore the alleged wrongs is anything that could have possibly happened during the entire time that Ms. Bartels was a resident of Franklin Manor, whether in tort, whether in contract, for injunctive relief related to any act or wrong or conduct by anyone at any minute of every hour of every day of the entire time that she was there. But that's not the law. The law of res judicata requires an analysis of the wrong. The wrong. And as the court in Bachweg said, well, you can have multiple wrongs during the course of conduct of a surgery. You could injure, we could go in, for example, here's a perfect example. I hire a plastic surgeon to do a facelift and a tummy tuck, and I pay the surgeon $30,000. Well, he doesn't do the tummy tuck, and part of that was the $15,000, but he messed up the surgery on the other part of it. Well, I can sue the doctor for breach of contract for not performing the surgery that I paid him to provide, but I don't have to include the other tort claim related to the separate act of messing up the other part of the surgery. They're two separate wrongs. And we have very separate wrongs, and in fact, this action involves two separate wrongs. And interestingly, as we pointed out in the record, and it's in the record and in our brief, is that one of the wrongs, the fall on November 4th, actually occurred because a housekeeper shoved Ms. Bartels off of her housekeeping cart, causing her to fall. Well, this wasn't revealed by the defendants until long after the experts had already been disclosed in this action and deposed. So how could the plaintiff have possibly pled anything related to that issue in the federal court action when that evidence was hidden for years? But defendants say, well, you had to, that included it. It included every potential wrong. Well, the defendants just simply ignore the pleadings. They put all of their emphasis on Judge Boyle's order. But the order is not what the court must examine. It's what was pled. What were the wrongs pled in the pleadings? And even the defendant's expert couldn't identify in the federal court action and stated, well, this doesn't relate to any specific event, because it didn't. The expert was exactly right. All the federal court action related to was a breach of the residency agreement, which required the defendants to provide certain services. Plaintiff said, you didn't provide the services that we paid for. That was it. And all of that hinged on, did the defendant's staff, a quantity of staff, that was needed to meet the residents' needs. There's a big difference between, oh, we supplied all the staff that we promised to provide. And that's what the ultimate conclusion of the federal court was, and that's all they had to decide.
But how do you determine what's the adequate number of staff?
The question is it doesn't matter, because the number of staff has nothing to do with whether the staff that were there complied with the standard of practice. They're two separate questions. Did you supply enough staff in the first place? All right? The issue...
Would it be enough staff to provide adequate care?
Well, the court concluded they supplied enough staff. The court didn't conclude the staff that were there complied with the standards of practice related to Ms. Bartels' falls in November the 4th and November the 13th. That wasn't required for the court to say, you supplied sufficient staff at a level that would be sufficient to meet the residents' needs, all right? You had, whether it's 5 staff working that day or 10 staff were needed, yeah, they were all in place, but that doesn't mean just because they were in place, they complied with the standards of practice. All it meant was they were there.
Well, is there any kind of, I don't know who would have this information, but, does the state have any requirements, as to how many staff members you must have, in proportion to the number of residents?
Yes, there's a state statute, and that was one of the arguments that was raised in the federal complaint, is what we call the objective standard. And in special care units like Franklin Manor, the state requires the facility to have 2.8 per day, per shift, a ratio, basically 1 staff for every 8 residents, okay? The defendants could have had 1 staff for every 2 residents, and staff way beyond the state minimums. But that has nothing to do with whether the people that were there, in sufficient numbers, complied with the standards of practice as it related to a fall, or maybe somebody fed someone the wrong kind of food and they choked on the food. Okay? Yeah, they had enough people there. They were doing everything. They had enough people to do what they needed to do, but the state case relates to the manner in which they did it, not whether they were there, but whether they acted in accordance with the standards of practice. 2 totally separate and distinct issues.
But how do you respond to the defendant's argument that the adequacy of care was what was actually litigated?
It wasn't litigated. It wasn't litigated because it didn't need to be litigated. And I think the point is, just because you throw in an expert report that says whatever it is the expert wants to say, doesn't make it an issue. All right? And so the defendants are taking the mission, well, my expert said it was. Well, just because they got an expert to write a report doesn't create an issue. They self-created the issue. I mean, they could have an expert say whatever they want, but just because it's in some report doesn't mean it has anything to do with the case. And so there was nothing litigated about Ms. Bartels' falls or her care in that case, and there's not one shred of evidence in the record that it was. On the contrary, it was all litigated in this action. Depositions of the people that worked there, depositions of the witnesses, discovery related to incident reports, depositions of all of Ms. Bartels' health care providers, all taken in this case. Not one deposition, no discovery, no evidence, not one piece of paper that is in the record that shows that anything related to Ms. Bartels' falls in November of 2015 were litigated in this case, because it doesn't exist.
Well, there were 12 depositions taken in the federal case?
No, the state case.
No depositions at all taken in the federal?
There were depositions, none of which related to Ms. Bartels' falls.
Right, so what were they of?
They were related to the breach of contract claim. But none of them are even in the record. So, I mean, I can't really discuss them because they're not in the record. They weren't offered by the defendants. And don't you think that if the issues related to the failure to comply with the standards of practice as it related to Ms. Bartels' falls and personal injuries were actually litigated in the federal case, that the appellants would have included those in the record? Well, certainly they would have, but they didn't. And the other important thing to note is, at the time the defendants filed their motion for summary judgment in the federal court case, experts had, the same expert that the plaintiffs had in the federal case was designated and deposed in the state case and offered opinions that the defendants breached the standard of care related to those falls. Yet the defendants stood by and now argue, oh, well, this was litigated in the federal case. Well, it wasn't. They knew all along that there were issues that they could never get summary judgment on related to the failure to comply with the standards of care, because we had experts that testified in deposition and we designated experts that offered those opinions in this case. It would have been impossible to get summary judgment on those issues. So the defendants have known all along that this state action has nothing to do with the claims that were in the federal action. All they're trying to do is take advantage of a few bits and pieces and words from a federal court order that's irrelevant, and that the law specifically states is not what the court should rely upon. The court must rely only upon the pleadings and then look from those pleadings and determine what was necessary to address the issues raised in the pleadings.
Counselor, you are arguing in your brief that the defendant's appeal should be dismissed because it does not, their claim does not affect a substantial right. Can you take us back to that jurisdiction a bit and walk us through that?
Well, I think I'm going to retract my position on that simply because I think our preference is to have this issue addressed now and not after we potentially go through a trial should the court dismiss the appeal. I'm going to kind of be Switzerland on that right now. Although I think it's up to this court to determine whether or not it does have jurisdiction and there was a substantial right, but I'm kind of going to take a neutral position on that right now. I know that doesn't help you much, Judge Flood, but that's where we are at this point in time. I think those are all the points that I have that were not addressed in the breach. Thank you very much for your time.
Thank you.
May it please the court, just want to briefly address a couple things. First of all, regarding the waiver issue, there is no procedural mechanism for us to move to dismiss or for summary judgment on res judicata or collateral estoppel until there is a final judgment. That is the requirement of both doctrines. So to say we somehow could have moved to dismiss, I am not aware of any procedural mechanism where that would have been possible. There is also no way for me as a defendant to unilaterally consolidate a state court action over into a federal court jurisdiction. That is not the law. It can't happen. And then that's why we objected directly in our answer that this was going on and then immediately filed the notice. In Bachweg, the key part of the consent was the defendants had stipulated to the plaintiff's voluntary dismissal of the one action. So when they brought it later, the court said you can't complain about claim splitting when you stipulated to the dismissal, which enabled it to come later. None of those situations are present here. Your Honor, I want to very briefly too address the idea of the thing about the federal court judgment being irrelevant. I mean, it is the element that is required for the doctrine of collateral estoppel or res judicata to apply. You have to have a final judgment on the merits. You have to analyze that judgment and what's in there to see whether or not the doctrine applies. Plaintiff is correct that in doing that, you also look to see if there's an alignment of the issues between the two actions. Briefly here, what he's talking about now are false. In the federal action, paragraph 49, what was alleged to be breach was assistance with walking and overall supervision to ensure that the plaintiff remained safe. And that the primary reason or the alleged failure for that was understaffing. That is exactly what is alleged here. If you look on in record, page 9, paragraph 44, plaintiff alleges that Franklin Manor did not provide adequate supervision to ensure that Ms. Bartels remained safe. It's the same thing as the contract. And that on paragraph 49, plaintiff alleges that defendant failed to provide adequate care and supervision, including the failure to provide assistance with walking. It's the same issues.
Well, how do you respond to his argument that the adequacy of staffing was based on the state statute?
He made that argument in response to our motion for summary judgment in the federal court. And the federal court rejected it. It's right in the federal court's order, this whole quantity versus quality. It said, no, I'm looking at your complaint. Your complaint is about whether or not the needs were met. That determination is binding on the plaintiff. If they disagreed or thought the trial court misinterpreted their complaint, they had but one option, to appeal to the Fourth Circuit. They can't collaterally attack that in this court. And Your Honor, the one issue there too is that plaintiffs, I think misses the point that, again, it's about claim splitting. The contractual duty and the tort duty may be different, but if they arise from assistance with walking, failure to properly supervise, they have to be brought together. They weren't, and it's barred by the doctrine against the prohibition against claim splitting.
If a staff member pushed plaintiff down or away from her cart, where does that fall in the list you were reading off of, the results of the inadequate supervision? Inadequate staff.
Your Honor, if the subject the alleged wrong is not providing assistance with walking, it's providing inadequate supervision, or in the federal court action, not meeting the other part was not meeting safety needs, not meeting supervision needs, that is related to that is the same alleged wrongful conduct, and so they must be combined there. I would like to address point on the appealability issue. In our reply brief, in there, we do talk about the inconsistent verdicts, but Your Honors, in this case, the analysis of the federal court judgment to show alignment of the issues, which talks about a substantial right, that is set forth in detail on pages 5 through 13 of our brief. It is lengthy because the federal court proceeding was so lengthy. We did not, thought for the court's convenience, want to repeat all of that again in the grounds for appellate review. And also, Your Honor, I see my time is up. Would you mind if I conclude?
Just briefly, very briefly.
Oh, I would just say for the reasons stated in our brief and oral argument, we respectfully request the trial court's order be reversed.
Thank you. That concludes oral argument in this matter. We'll take it under advisement. Thank you, counsel, for your excellent arguments this afternoon. We may adjourn.
All rise. This session of the North Carolina Court of Appeals is adjourned. Hey, Scott. Good to see you again.